I'm going to introduce Peter Weiss. Peter Weiss was at the center when I got there in 1971, and he's the person who always insisted we had international law to every single legal filing we ever made. We thought it was just ridiculous. And then in 1981, of course, he wins the Filartica case, which is what started bringing home the idea that torture could be prosecuted anywhere in the world. And he's still with us on all that. Peter was one of the people that, along with Wolfgang Kolek and some others, who helped found the European Center for Constitutional and Human Rights. He's on the board of the ECCHR. He's vice president of the center. He's he's president of the Lawyers Committee on Nuclear Policy. He's on the on the executive committee of Americans for Peace Now. A million pieces of incredible activism, but really solidly solidly with the idea that we can have peace through application of international law, and that's been his role for all of us as really a leader of the Center for Constitutional Rights. So we're glad to have Peter come up here and give a talk. Thanks, Peter.
Thank you, Michael. Michael always says that about me. Whenever I see a brief, I say, put in some international law. But not everybody pays attention. So here are my 12 minutes. I have a confession to make. In preparing to deliver these brief remarks, I have come to a new appraisal of John Yoo, the man everybody hates. How has this come about? Let's consider the most recent pair of contract decisions. Al-Shamari versus Kaki and Al-Qurashi versus L3 Services. There, on September 21, just 5 days back, the Fourth Circuit, in an interlocutory appeal, ordered the dismissal of complaints of torture based inter alia. There were many allegations. The one that struck me was the allegation that the defendants had dragged one of the plaintiffs around a room by means of a rope tightly secured on his penis. The theory behind the dismissal was that the contractor defendants were integrated into the military and therefore entitled to benefit from something called battlefield preemption. Although this particularly ingenious method of torture was set in motion at Abu Ghraib, which at least until last Wednesday had not been regarded as part of a battlefield. The 2-1 decision, and I want to stress 2-1 because many of these terrible decisions have wonderful dissents. And we all know that today's dissents are tomorrow's majorities, right? The 2-1 decision disposed of the only remaining issue in the two cases, whether they could proceed to trial on violation of state law. But the court left little room for any alternative, holding that, and I quote, conduct carried out during war and the effects of that conduct are, for the most part, not properly the subject of judicial evaluation, end quote. So much for the prosecution of war crimes. You have probably heard this morning, and will hear before the end of the day, other instances of the judicial acrobatics by which the courts, with guidance from the administration, have managed to evade the most rudimentary requirements of justice while paying lip service to abstract principles of accountability. What is happening here is reminiscent of what happened under Pinochet, who promulgated scores of executive decrees tearing the Chilean constitution to shreds, but enabling him to say, "You don't like what I'm doing? It's all legal." So back to you, who is on record as saying that whatever the executive decides is needed for national security is legal. Is that not preferable to the endless academic debates? Excuse me. Which fill up cyberspace and op-ed pages with scarcely a mention of such old-fashioned values as justice, humanity, and rights. Don't take me too serious about that. I'm not a great admirer of John Yoo. I just think his approach has a kind of elegant simplicity. But far be it from me to leave you with a message of undiluted gloom. We may be passing through something of a constitutional slump at the moment, but you are not wasting your time and money at this seminar. Looking at things from my octogenarian perspective and my more than 40 years with the Center for Constitutional Rights, I see a lot of situations where the law has failed. And I also see a lot of situations where the law has succeeded in nudging history in the right direction. Some examples. Our black president has disappointed many of us, but having a black president is not to be discounted. We couldn't keep Troy Davis alive, but the death penalty is almost on its deathbed. Gay men and boys are still succumbing to suicide and murder, but same-sex marriage is on a path of legal recognition from one reluctant legislature to another. Bush, Cheney, and Rumsfeld are not likely to sit in a dock in my lifetime, but these things, as has been said this morning, take time. 2 years ago, Ellen Lutz was able to publish a book titled Prosecuting Heads of State, telling the story of several dozen such prosecutions. The principle of universal jurisdiction, which is at the heart of our meeting today, is now generalized in theory, if not yet in practice. But in my opinion, it is the most important addition to international law since the Universal Declaration of Human Rights. Women still have a long way to go to secure their rightful place in peace-related decision-making, but Security Council Resolution 1325 gives them a legal instrument with which to pursue this path. I could go on, but I think you get my point. Let me now go to something completely different, as those four Brits in Monty Python used to say. Human rights work is unbelievably hard work. It can also be dangerous work, requiring more than the normal dose of courage. In case you need to be convinced of this, I suggest you make your way sometime this week down to the Cinema Village on 12th Street and watch a movie called Granito. It is a film about a film. 15 years ago, a young woman named Pamela Yates went to Guatemala and made a movie, When the Mountains Tremble, about the repression of the landless indigenous people by a government doing the bidding of the small landed aristocracy. 200,000 people died in this struggle, and some of the oppressors are currently under investigation by a Spanish court, which has agreed for the first time, I'm told, in Spanish judicial history, to accept video evidence, in this case, clips from the original movie. Granito, which is Spanish for small grain, as in grain of sand, is the name of the new film, which tells the story of this progression from art to justice. It demonstrates how this human rights case, like most human rights cases, is put together as an accumulation of thousands, maybe tens of thousands, of tiny grains. Go and see it, and then decide if you still want to be a full-time human rights lawyer. And incidentally, the film's editor is Peter Kenoy, son of the late Arthur Kenoy, CCR's beloved guru. In closing, I want to close on a high note. Let me share with you some excerpts from a recent decision of the European Court of Human Rights, Alskani v. United Kingdom. Sarah mentioned it this morning. The case held that the European Convention on Human Rights applies to the conduct of UK armed forces in Iraq. Here are some gems from the concurring opinion by the Maltese judge, Giovanni Bonello. I quote, "I confess to be quite unimpressed by the pleadings of the United Kingdom government to the effect that exporting the European Convention on Human Rights to Iraq would have amounted to human rights imperialism. For my part, I believe that those who export war ought to see to the parallel export of guarantees against the atrocities of war. At my age, it may no longer be elegant to have dreams, but that of being branded in perpetuity a human rights imperialist, I acknowledge, sounds to me particularly seductive." End of quote, end of remarks.